Hello and welcome along to today's webinar, An Employer's Guide to Contracts of Employment. My name is Kieran Robertson and I am an Employment Law Advisor here at Ellis Whittam. So before we get started, a few bits of housekeeping. Number one, to listen to today's webinar, please use your computer speakers. Number two, you can access our definitive guide, which contains all the information we will discuss today. Finally, three, if you're having trouble accessing the webinar today, let me know in the questions box and I will come back to you after the event. For those unfamiliar with Ellis Whittam, we provide high quality, fixed fee employment law and health and safety advice. We employ qualified solicitors and health and safety advisors who develop one-to-one relationships with our clients as we provide you with a named advisor to help you with your HR and health and safety journey. We don't just advise, we provide hands-on support and have a range of additional services that employers can take advantage of. We are currently supporting over 17,700 UK employers, from startups to national brands, and really are experts in our field. We currently have more than 95% client satisfaction rate, something that we are proud of here at Ellis Whittam. Let's have a look at the agenda for today's webinar. Part 1 will focus on the contract of employment. Part 2, the Employee Handbook. And finally, Part 3, the Good Work Plan. So what are we going to take a look at in Part 1? Number 1, do I need to provide my employees with a written contract of employment? Number 2, does the contract need to be signed? Number 3, what are the different types of contracts? Number 4, can I agree whatever I want with the employee? Number 5, how is a contract of employment terminated? And finally, 6 things to take away. So let's get started. Does an employer need to provide employees with a written contract of employment? Well, first things first, the contract of employment sets out the rights and obligations of both the employer and the employee. Contrary to popular belief, a contract of employment does not have to be in written form to be legally valid. It may be a written and signed document, but equally, it may be a verbal agreement. However, if you entered into a contract of employment verbally, you're still required to provide each employee whose employment is to continue for more than 1 month with a statement of written particulars of employment. The current legal position is that this must be provided within 2 months of the employee's start of employment. It should be noted that as of the 6th of April 2020, all staff will be entitled to a written statement of terms on or before the first day of employment. This right will apply to both employees and workers. This change is due to the introduction of the Good Work Plan, which we will touch on later in the webinar. The statement must include the following information: the employer's name and address, employee's details, name, job title, job description, start date. Salary, including payment intervals, for example, weekly, monthly. Notice periods, hours of work, holiday entitlements, and details of any applicable collective agreements. Not the shortest of lists, and it is understandable that some employers get this wrong. Just a word of warning here: employers who do not provide a written statement or don't specify everything required can face claims in an employment tribunal. There is no legal requirement for the written statement to include detailed information about sickness absence and sick pay, disciplinary and dismissal procedures, and grievance procedures, but you should say where the information about these topics can be found. They should be in a reasonably accessible document, ideally the Employee Handbook. My expert tips: although a contract of employment or handbook are not legal requirements, it is strongly advised for all employers to have contracts setting out rights and obligations and a comprehensive handbook laying down workplace rules and policies. Get your contracts of employment and employee handbook drafted by a legal expert. Our employment law advisors can do this for you. making it tailored to your organisation. Does the contract need to be signed? Well, the starting point is that there is no statutory obligation to have the contract of employment or the written statement of particulars signed. The key ingredients to a contract are that there is an offer, acceptance, consideration, and the intention to create legal relations. Once the applicant has accepted the job, there is a legally binding contract of employment between the employer and the applicant. The law does not require witnesses or a signature to make it valid, although a signature is recommended. What is worth bearing in mind is that an employer cannot use the fact that an employee has not signed a contract as a way to deny employees their statutory rights. For example, to not allow them to take their annual leave. Equally, it does not give an employer an excuse to make changes to an employee's contract, such as reducing their hours or pay. My expert tips: it is best practice to have the employee sign and date the contract and return it back to you for three main reasons. Number one, it proves you are complying with your legal obligations to provide an employee with a written statement of particulars. It makes it clear what terms and conditions were agreed between the parties in case a dispute arises in the future. It is also important to have a signed contract in order to rely upon restrictive covenants and any 48-hour opt-out working under the working time regulation. You should keep a copy for your records and then provide them with a copy for their own records. But what about electronic signatures? Well, a signature can be handwritten or provided through electronic means. It can take the form of, for example, typing your name in full, using your finger or pen to touch on a touchscreen device, or electronically pasting in your signature. My expert tip here is that if you do use electronic signatures, it is recommended that you should give the employee a printed copy or send an electronic version that clearly shows their signature. Moving on, what are the different types of contracts? There are numerous types of contracts, so let's take a look at them here. Indefinite contracts. This is the most common form of contract used to run your core business activities. You may hire someone on a permanent, full-time, or part-time basis and pay them weekly or monthly. Fixed-term contracts. This is a contract that ends on a specified date or when a particular event or task is completed. Fixed-term contracts can be very useful to cover a period of maternity leave or long-term sickness, to do a job where funding has been provided to undertake a specific task, or to do some seasonal work. 0 hours contracts. A 0 hours contract is a contract between an employer and an individual whereby the worker has no guaranteed hours and is only paid for the work they actually carry out. This means employers do not need to give them work and the worker does not have to accept the work offered to them. It allows employers to have a pool of people available. This allows an organisation to respond quickly and effectively to any fluctuation in business demands. For example, to deal with an unforeseen event, cope with absences, or in the build up to a busy period. Freelancers and consultants. Taking on a freelancer, contractor, or consultant can be a good option for an employer who needs someone to work on a specific project. It allows you to get talent in without taking someone on a permanent basis. For these types of individuals, a contract for service will need to be drafted, which clearly establishes the rules between you and the self-employed contractor. It is essentially a commercial agreement and must accurately reflect the actual working relationship and should cover, amongst other things, how long the agreement will last, how it can be terminated, the rules on shared services, etc. Given the press around contracts of employment at the moment, it is certainly worth taking advice on the drafting of this agreement. Agency workers. The agency worker will have a contract with an agency, but they will work on a temporary basis for a hirer. The basic premise is that it is the agency that has the responsibility to pay the worker and ensure that they receive their rights. Therefore, there are fewer obligations than when employing permanent staff. Agency workers are useful as they can step in at the last minute and provide cover for sickness, family related leave, or absences for unforeseen or emergency matters. Alternatively, they can help a business respond to a seasonal rush or a sudden increase in demand. They can also cover a position while you find a suitable permanent option, or provide a niche skill within your business that your other employees simply do not have. Director service agreements. When employing people as directors, you should draw up a director service agreement, which covers duties, restrictions during employment, remuneration, for example. Do note that there are maybe additional issues to cover off in the agreement if you are a PLC or working within a regulated sector. For example, financial services. So take advice to make sure that you are getting this right. Apprenticeship agreements. There are different types of apprenticeship agreements. There are apprentices on a framework apprenticeship and those in the new approved English apprenticeships. In addition, there are modern apprenticeships, which carry with them full enhanced protection. Depending on the type of agreement, different provisions need to be included and different rules apply in Scotland. My expert tip: when employing apprentices, there are a number of things that need to be included in the contract of employment, otherwise, the apprentice may end up with enhanced protections. Always seek advice when taking on apprentices to ensure that the contract you're using complies with the relevant law and you do not face nasty surprises if you wish to dismiss them. Volunteer agreements. Often, organisations will draw up an agreement with the volunteer which usually covers their role, training, supervision, expenses, health and safety, and insurance. There is a warning here. You need to take care when drafting the agreement to ensure that it could not be regarded as creating a contractual relationship. Secondment agreements. If you are temporarily assigning an employee to another organisation, you will need to enter into a secondment agreement, which sets out the rights of the secondee and the obligations of the employer and the host business. My expert tip when it comes to deciding on the best contract is to get it drafted by a lawyer. Our employment law advisors can draft whatever you need to ensure legal compliance from an employment law perspective. Your advisor will be familiar with working with other employers in your sector, so you will benefit from experience of implementing best practice in other organisations. So, can an employer agree whatever they want with the employee? Well, the simple answer is no. Let's talk about statutory terms. The law establishes certain minimum duties and obligations that all employers must abide by. For instance, you cannot agree with an employee that you will pay them below the applicable national minimum wage or national living wage. And as a warning, the law will override the agreed terms that do not fulfil statutory duties. There is also something called implied terms. Every contract contains certain terms that are implied. This means that even though they are not written down, they still need to be followed. So, even if it's not mentioned in the contract, implied terms will include the following. Employers must provide a safe working environment for all their employees. Employers and employees have an implied duty to maintain a relationship of mutual trust and confidence. Employees have a duty to not breach their duty or fidelity. And employees must follow reasonable and lawful orders. The reason they may not be explicitly included is that they may be very obvious, but all the duties explained above are necessary to make the contract work. We also need to consider custom and practice. This is where some terms may be implied if there is a long-standing or established practice in place. An example is that employees must be paid overtime for any additional hours, or they will receive a bonus at Christmas. Although the contract does not say this, and the employer has never sat down with the employee to specifically agree to it, it can form part of the contract. This is known as custom and practice. Custom and practice is likely to override an express term in the contract, but can be a Very tricky area of law to navigate, so do take advice. There are also incorporated terms to consider. These are terms that are included in other documents, such as the Employee Handbook. These should be incorporated into the contract of employment. Typically, employers will need to consult before making a change to a contract of employment. But what about your Employee Handbook? If the Employee Handbook is not contractual, it allows employers to vary its content without requiring the formal consent of its employees. My expert tip here is that you should clearly state that the contents of the Employee Handbook do not form part of the terms of their contract of employment, unless otherwise stated, and that you may need to amend any policy or procedure to ensure that it remains relevant and consistent with the law and the needs of the business. However, changes should not be made which could breach trust and confidence between you and the employee. You should also state that you will notify them and provide them with an up-to-date copy of the handbook when changes occur. It will also mean that if you violate a procedure or policy in the employee handbook, it will not constitute a breach of contract. If you have a contractual handbook, then take advice before moving away from it. If it is not done properly, it could land you in some very hot water. A warning though, whether your handbook is contractual or not, if you violate a procedure in an employee handbook, an employment tribunal will see if you have followed your own internal procedures and look at the reasons why you deviated from it. Don't forget, even if the handbook is not of a contractual nature, employees are still under an implied duty to follow lawful and reasonable orders and abide by the terms of the handbook. So finally, how is a contract of employment terminated? This can occur in a number of ways, namely resignation or dismissal. Firstly, let's look at resignation. In order for an employee to resign, the employee must give you the required amount of notice, which should be stated in the contract of employment. If there is no provision in the contract, they should at least respect the statutory minimum of a week. It's always a good idea to ask the employee to confirm their resignation in writing. Depending on the terms of the contract, employers have a few options. You may ask the employee to work their notice period. You may place the employee on garden leave. This means you may ask them not to come into work during their notice period in order to keep the employee away from the business, sensitive information, and from clients or suppliers. This must be expressly laid down in the contract though. You can ask them to leave immediately, but you'll need to make them a payment in lieu, and again, this must also be explicitly expressed in the contract. Whatever you decide, you will need to confirm to the employee when their last day is and how the notice period will be handled. There are some cases when employees resign with immediate effect, and this could give rise to a claim for constructive dismissal. If this occurs, make sure you take advice. Another way it can come to an end is dismissal. This is where an employer dismisses an employee. A dismissal will be considered potentially legally fair when an employer can show that the dismissal was for one of the following reasons: related to an employee's conduct, for example, theft; related to an employee's capability or qualification for the role, for example, long-term sickness absence or performance; redundancy, for example, business closure; a statutory restriction that prevents the employment continuing, for example, a driver loses his driving license; some other substantial reason, for example, an employee is handed a long prison term. It is not enough that the employer has a valid reason. You must have acted reasonably in the circumstances and treating it as a sufficient reason for dismissing the employee as well. So looking at some of these then. Firstly, misconduct. In a nutshell, the employer will be able to dismiss on the grounds of conduct if they carry out any necessary investigation, inform the employee in writing of the issue, invite them to a disciplinary hearing, show them copies of any evidence, and allow them to be accompanied to the meeting, and allow an appeal. The tribunal will look to see whether the employer's response to the misconduct fell within the band of reasonable responses. If, in the tribunal's view, no reasonable employer in the circumstances would have dismissed the employee, the dismissal will be considered unfair. Typically, employees need 2 years of service with you before they can submit a claim to the Employment Tribunal for unfair dismissal. Gross misconduct is an act which is so serious that it justifies dismissal without notice or pay in lieu of notice for a first offence. They must be acts that destroy the relationship of trust and confidence between the employer and employee, making the working relationship impossible to continue. Employers often erroneously think that they can rip up the contract and fire someone on the spot for acts of gross misconduct, but in reality, you still need to follow a fair procedure. If you do dismiss them instantly, it's as likely that you will face a claim of unfair dismissal. My best advice here is to take advice before embarking on any disciplinary process. Getting it wrong can be very costly. So, what about redundancy? In redundancy situations, there are certain elements which are crucial to a fair redundancy process, such as warning employees of redundancies, creating and applying fair and non-discriminatory scoring criteria, consulting with employees and thinking about suitable alternative employment options. Getting the selection or consultation process wrong can render the dismissal unfair. There are more added hurdles when you're conducting a collective redundancy, i.e., where you want to make 20 or more employees at one establishment redundant within the space of 90 days. So take advice. There is also long-term sickness absence dismissals. In cases of dismissals for long-term sickness absence, an employment tribunal will look to see that you consulted with the employee and explored how to support them back into work, made the necessary reasonable adjustments, especially if the employee is disabled, sought medical evidence that confirmed that the employee is not likely to return at all or for a prolonged period, and you warned the employee that their long-term absence could lead to dismissal. Fixed-term contracts is another way. If a contract of employment is for a fixed-term period, the contract will automatically terminate when the period ends. The non-renewal of a fixed-term contract constitutes a dismissal in law. This means that an employee may be able to claim unfair dismissal if they have over 2 years' service. They may be able to succeed in their claim if they show that the employer failed to renew their contract for a fair reason or for not following a fair procedure. As is frequently the case, the non-renewal of a fixed-term contract will be potentially fair on the basis of redundancy, as there is not enough work for the employee. Sometimes, the reason may be fair for some other substantial reason. For example, the fixed-term employee has been clearly recruited to cover maternity leave, and their employment will be terminated when the other employee returns. So take advice when considering your options. When it comes to any type of dismissal, notice periods are certainly something employers need to be getting right. An employer must provide a week's notice if the employee has worked for an employer on a continuous basis for 1 month or more, but less than 2 years. You must provide 2 weeks' notice if the employee has worked for you on a continuous basis for at least 2 years, and an extra week for each further year of completed service, up to 12 weeks' notice. The employee's contract of employment may also expressly have a provision that permits making a payment in lieu of notice, known as a pile-on. Dismissals can be tricky, and so I would always suggest that you take advice. If you have a dismissal looming, then get in touch. We'll be able to make the process smoother and more manageable for you. So 6 things to take away. Number 1, a contract of employment does not have to be in written form to be legally valid. However, if you entered into the contract of employment verbally, you're still required to provide each employee whose employment is to continue for more than 1 month with a statement of written particulars of employment. This must be provided within 2 months of the employee's start of employment, although that is subject to change following the introduction of the Good Work Plan, which we will touch upon later in the webinar. Number 2, it is highly advisable to issue a written contract of employment to each and every employee. Having a written contract can give you more protection than an unwritten implied contract that lays down your obligations and their obligations and rights. Although it is not a legal requirement, it is best practice to have the employee sign and date the contract and return it to you. Some terms may be implied if there is a long-standing or established practice occurring. In most cases, making changes without the agreement of the employee may be considered a breach of contract. Take advice. A contract can be terminated if an employee resigns or they are dismissed. So my very best tip is to take advice. Now, there is still so much more to talk about when it comes to contracts, and so if you would like to have an overview of what we have discussed today, or want to find out more about how to change contracts of employment, please download our definitive guide. The details of how to do this will be contained within our follow-up email. Now turning our attention to part 2 of the webinar, which will focus on employee handbooks. So what we're going to cover in part 2, well, number 1, is it a legal requirement to have an employee handbook? Number 2, if it's not a legal requirement, what's the point? Number 3, how can I implement an employee handbook effectively? Number 4, why do they need to be reviewed regularly? And finally, number 5, 6 things to take away. All employers want to have a happy, motivated, and effective workforce to ensure high business productivity and a low staff turnover. To assist with this, you need employee handbooks, which contains workplace rules, standards, and procedures. These policies help the smooth day-to-day running of the organisation and let employees know what is expected of them, their rights, and what happens when things go wrong. In this webinar and our definitive guide, we will offer you expert tips and highlight common pitfalls to reduce the risk of expensive tribunal claims. So let's get started. Is it a legal right to have an employee handbook? Is it a legal requirement to have an employee handbook? The law does not impose an obligation on employers to have an employee handbook, but there are certain policies that must be provided to staff. Under the Health and Safety at Work Act 1974, all employers who have 5 or more employees must have a written health and safety policy. So it is key to consider this when your organisation has more than 5 employees. From a disciplinary and grievance perspective, the ACAS Code of Practice on Disciplinary and Grievance Procedures clearly states that the employers should have a written disciplinary and grievance policies. Although it is not legally binding, the Code of Practice is referred to by employment tribunals. This means that if an employee submits a claim to an employment tribunal, the tribunal will take into account whether the ACAS Code of Practice has been followed. A little word of warning in respect of this. If the employee succeeds in their claim and it is found that the employer unreasonably failed to follow the Code of Practice, the compensatory award may be increased by up to 25%, something that can be easily avoided. Although an employee handbook may not be a legal requirement, it is strongly advised for all employers to have workplace rules and policies in place. Here are 6 reasons why. Number 1, it sets out your expectations and the law. Having written policies and procedures gives you the chance to clearly communicate your expectations to employees, setting out the rules and standards for your workplace and what will occur if there are breaches. For instance, a sickness absence management policy allows genuinely sick people to know how you will support them, and malingerers that you can and will take disciplinary action. Likewise, it can help employees understand the law. For example, since 2007, smoking is not permitted in any enclosed workplace or in any work vehicle that is used by more than one person. Laying this down in a policy makes employees aware of legal do's and don'ts and avoids them getting into trouble. Remember, for certain sectors, you will need to highlight key rules. If your business deals with food or drink, health and safety is very important. Therefore, you should lay down specific rules employees need to follow. For example, always wearing a hairnet while preparing food. It gives your managers the tool to decide. It gives your managers the tools to deal with difficult situations. Having pre-agreed rules means managers do not waste time deciding how to respond to a situation. For example, if an employee wants to make a complaint, the manager can refer to the grievance procedure and follow the steps set out. Likewise, the employee will know what the process entails. Number three, it ensures consistency and fairness. Having your managers follow the same policy or procedure prevents them from taking different steps in similar cases. Adopting one standard for everyone means that there is consistency in approach and less likelihood of claims, for example, discrimination. It improves staff productivity. When people are at work, you want them to work. Therefore, you may specify, for example, that employees with access to the internet should use that access in a reasonable fashion, and that excessive personal use during working hours will be treated as misconduct. If employees know that they can face disciplinary action, it may act as a deterrent and increase their productivity. Number five, it protects your organisation. This is particularly true when you think about social media. You should have a clear and robust social media policy which clearly sets out guidelines on what is and what is not permitted, both at work and at home. You should emphasise that any offensive, discriminatory, or defamatory comments, images, or videos about the company, their managers, colleagues, clients, or service users will be subject to disciplinary procedures. This can help prevent any behaviour that could cause significant reputational damage to your company. Number six, it helps with claims. Employers often find themselves making costly procedural mistakes when disciplining or dismissing an employee for misconduct. They may have a fair reason for dismissal, but if they have not followed a fair procedure, this can render the whole process unfair. Having a clear, legally compliant, and well written procedure can reduce the likelihood of running into legal action, and if a claim is issued, give you a better chance of successfully defending it. How can you implement an employee handbook effectively? Having an employee handbook in place is a great start, but you also need to ensure that it is implemented successfully in your workplace. A good starting point is to discuss it with employees. It is easier to get people on board if you discuss rules and policies with them directly or with employee representatives. Talking through what you talking through what you are planning to introduce or change will let them understand the rationale behind the rules and give them the chance to raise their viewpoints and concerns. The second thing to consider is to adapt according to your business culture. Make sure the rules you adopt are effective for the size, nature, culture, and values of your business or organization. You should always take care when you're drafting your policies. Are you being too rigid and essentially shooting yourself in the foot? Or are you being far too flexible and risking the policy becoming vague and uncertain? Expert tips. You should seek legal advice when drafting the provisions of policies. Our employment law advisors are best placed to draft the employee handbooks for you. They can tailor the employee handbook to suit your business and sector. Communicate the policies to staff. It is not enough to just have a specific policy or procedure. Your employees need to know about it. It is essential to make sure the employee handbook is easily accessible for all employees. Give them printed copies. Put important policies on notice boards in common areas. Upload to the company intranet, etc. My expert tips are that you should provide the employee handbook as part of the new member of staff's induction. Get employees to sign a receipt to show that they have read the policy. This way, they cannot argue that they are not aware of the rules and your expectations. If you have employees whose first language is not English, take steps to ensure they understand the policy. For example, you can get the policy translated into their native language or provide a thorough induction. Have systems in place to support your policy. You need to have systems in place to support the policy. For example, if your IT policy bans gambling, social media, or online shopping websites, you should have a filtering system in place to prevent employees accessing those sites. Train your managers. Train your managers to make sure they understand how to implement these policies and procedures fairly and consistently. Review this training to ensure it is kept up to date. Manage breaches. If you notice that a high percentage of employees are violating a particular policy, you may need to take action to resolve the issue. You may need to give specific training to ensure people know what is expected of them, or send a memo around reminding employees of the rules. Finally, you should monitor to make sure that your employee handbook is reviewed and updated if and when required. If your employee handbook is not of a contractual nature, it allows you to make changes to its contents without requiring the formal consent of its employees. We will go into this later on in the guide. Why do they need to be reviewed regularly? There are a number of reasons why employee handbooks need to be constantly monitored and reviewed. Number one, new legislation. New laws come into force, meaning employers need to take steps to ensure that they are legally compliant. In 2015, shared parental leave was introduced, providing new parents with more flexible options when deciding who will take time off to care for the baby. The mother can end her maternity leave early and share up to 50 weeks of the remaining leave entitlement with the father of the baby or her partner. This meant that employers had to think about creating a new policy that highlighted this right, explain how it worked, what notice needs to be given, and how much they are paid. Number two, new judgments. Employment appeal tribunals and higher courts will also issue judgments which can impact on the law. Number three, cultural changes. Society changes and shifts with time. With the phenomenal rise of technology, employers have to react and try and anticipate changes that affect their workforce. 15 years ago, Facebook, Twitter, online shopping, and Pokemon Go weren't even around, but now everyone seems to be addicted to the latest apps and websites. We need to make sure policies such as social media and IT are kept up to date and are fit for purpose. Number four, business changes. Your business may change too, and you will need to make sure that your policies reflect the changes that are taking place. 6 things to take away. Here are 6 things you should know about employee handbooks and HR policies. Number one, policies need to be read by employees and applied fairly and consistently by managers. Number two, seek legal advice when drafting employee handbooks/policies. Number three, all employers who have 5 or more employees must have a written health and safety policy. Number four, it is beneficial to have systems in place to support policies. Number five, you should provide the employee handbook as part of a new member of staff's induction. Number six, make sure that all policies are monitored and updated when and if necessary in line with legislative developments and changes to the business. Now, there's still so much to talk about when it comes to employee handbooks and policies. And so, if you would like to have a detailed overview of what we have discussed today or want to find out more about number one, what kind of policies and procedures should I include? And number two, how can I change the employee handbook? Then please download our definitive guide. The details of how to do this will be contained within our follow-up email. Now, part 3 of the webinar. The final part of the webinar focuses on changes coming into effect from April 2020 onwards. In 2018, the government produced its Good Work Plan, setting out several proposed changes to employment law intended to improve the rights of employees and workers. We provide a rundown of 3 significant changes that are set to come into force on the 6th of April 2020, plus a number of other changes planned for which an implementation date is not yet set. changes that will come into force on the 6th of April 2020. Number one, written terms. Number two, a week's pay. And number three, contents of contract. Written terms. Currently, an employer has 2 months from the date an employee/worker starts work to provide them with a written statement of their terms and conditions. As of the 6th of April 2020, all staff will be entitled to a written statement of terms on or before the first day of employment. This right will apply to both employees and workers. A week's pay. The reference period to determine an average week's pay for holiday purposes will increase from 12 weeks to 52 weeks. Contents of contract. From the 6th of April 2020, a contract of employment must contain the following additional information about the terms and conditions of employment. Normal working hours, including the times of the week when the employee/worker is required to work, whether these hours or days may be variable, and if so, how they may vary. Any benefits other than pay that the employee/worker is entitled to, including non-monetary benefits such as vouchers or meals. Any probationary period, including the duration, to any conditions. Sick pay entitlement. Details of any other paid leave such as maternity leave and paternity leave. Any training to be provided by the employer and details of any mandatory training that the employee/worker must complete. Existing staff who have contracts prepared before the 6th of April 2020 will be entitled to request a new version contract, which you would be required to provide within 1 month. Changes that are due but have no implementation date. Number one, continuity of employment. Number two, 0 hours. Continuity of employment. There will be a change in legislation to help casual employees acquire continuity of employment so that they benefit from employment rights. It is proposed that a gap of 4 weeks rather than 1 week will be required to break continuity of employment. There is currently no date set for the introduction of this change. 0 hours. After 26 weeks service, a 0 hours contract who tends to work a certain number of hours each week will have the right to request a contract guaranteeing that number of hours. This will be dealt with in a similar way to a flexible working request, meaning employers will be required to genuinely consider any request they receive. There is no date yet for the introduction of this provision, but it is expected that this will be introduced in April 2020. So that brings us to the end of our webinar today. Thanks so much for joining me. I have really enjoyed having you on board. If you have any questions, then do pop them in the question section and we will come back to you with the answer. At Ellis Whittam, our employment law advisors and health and safety consultants are on hand to help you understand your legal obligations and make the whole process easier and smoother. And so, if you have any questions about today or our services generally, then do get in touch. Contact details are right there for you and will be in a follow-up email after this webinar. I hope you have a great day.